On March 23, 2010, the Affordable Health Care Act was signed into law by President Obama following passage by Congress. Critics have referred to this law as Obamacare. The Affordable Health Care Act, formerly known as H.R. 3962, has stimulated conversations about women's health insurance, contraceptives, and religious liberty. The U.S. Conference of Catholic Bishops' opposition to birth control has been front and center of this discussion. Equally important are questions about whether this law is permissible under the Commerce Clause of the U.S. Constitution. The Nonpartisan Congressional Budget Office, CBO, established to provide Congress with basic budget data and analysis, estimates the cost of this law to be $940 billion over 10 years. The CBO further estimates this law will reduce the federal deficit by $143 billion over 10 years and $1.2 trillion over 20 years, compared to the cost projections for health care if Congress had not enacted this law. This means the law is projected to save American taxpayers billions of dollars. The question is, what does the Affordable Health Care Act do, and why has it become a political lightning rod? This law establishes comprehensive health coverage insurance that, if not struck down by the U.S. Supreme Court, will expand coverage to at least 30 million Americans who are not currently insured. It covers underemployed, unemployed, and middle-class American families whose primary providers have lost their jobs and their insurance coverage through no fault of their own. Certain changes became effective upon passage. Other changes have taken effect to date, and most of the changes will take effect by 2014. Specifically, the Act provides a 50% discount on name-brand drugs for 4 million Medicare-eligible seniors, expands health coverage for young adults, provides small business tax credits, authorizes pre-existing condition insurance plans for those otherwise uninsured, cracks down on healthcare fraud, expands coverage for early retirees, establishes online insurance information, provides free preventative care, prohibits insurance companies from rescinding coverage, authorizes appeals of insurance company decisions, provides consumer protection services, establishes cost containment and improvement of quality care mandates, requires individuals to purchase insurance coverage, expands access to Medicaid, eliminates lifetime limits on insurance coverage, regulates annual limits on insurance coverage, governs unreasonable rate hikes by insurance companies, reduces healthcare costs, and establishes affordable insurance exchanges, among other things. This law has generated controversy, giving rise to expressions of outrage among members of Congress, the Catholic bishops and other religious leaders, women's health rights groups, radio talk show hosts on both sides of some issues, and state attorney generals, culminating into a historic battle now brewing after having been thoroughly stirred by competing lawyers before the 9-rope justices of the U.S. Supreme Court. One provision of the law generating considerable controversy is the preventive health care mandate scheduled to take effect January 1, 2013. This provision expands the number of Americans receiving preventative care and mandates the inclusion of contraceptives for purposes of women's health care. On January 20, 2012, the Obama administration issued a ruling through the Department of Health and Human Services requiring most health insurance plans to cover preventative services for women, including recommended contraceptive services, without charging a copay, coinsurance, or a deductible. That order further stated nonprofit employers who, based on religious beliefs, do not currently provide contraceptive coverage in their insurance plans will be provided an additional year until August 1, 2013 to comply with the law. This ruling caused a storm of protests from Catholic Church leaders, including Cardinal Dolan of the New York Archdiocese. The heart of the Catholic objection, as voiced by Bishop Richard Lennon of the Cleveland Catholic Diocese, saying, unless this rule is overturned, Catholics will be compelled to violate our consciences or drop health care coverage for our employees. In response to opposition, the Obama administration announced on February 10, 2012, an accommodation to the contraception rule. Instead of requiring religious-affiliated employers to pay for contraception, the administration mandated that health insurance companies would provide contraceptives free of charge to the consumer. The Coalition to Protect Women's Healthcare has mobilized and initiated petitions and other activities to protect women's healthcare and equal rights. This group and other affiliated or related organizations have celebrated HHS guidelines guaranteeing all new insurance plans will cover preventative services as defined by HHS with no copay. They view mandatory contraceptive as required by HHS as a health issue. Men have been in the forefront of the vanguard of opposition to inclusion of contraceptives in employers' health care plans. The other provision of the law that is hotly debated is the mandate requiring individuals to purchase affordable health insurance. The mandate raises a serious technical issue as to whether Congress has the power, under the Commerce Clause of the U.S. Constitution, to force an individual to purchase health insurance. The U.S. Supreme Court is expected to issue a decision in June 2012 concerning challenges to the constitutionality of the Affordable Health Care Act. If you are concerned about healthcare in America or about government infringement of religious and other rights, go to electedface.com right now and vote in our poll before May 30th, 2012. We will share these results with the media and with your representatives in Congress.